Well, welcome and profound congratulations on making the finals here on Monday. It's really an awesome accomplishment. As John said, we'll introduce ourselves first and then ask you to introduce yourselves, and then we'll read you the question. My name is David Hudson. I'm a First Amendment Fellow with the Freedom Forum Institute, and I teach law at Belmont University in Nashville, Tennessee.
Good to see you all. I'm Hank Chambers, a law professor here at the University of Richmond. So it's good to see you all. Look forward to a good conversation.
Sorry, I was thinking about something. My name is Ben Glickman. Congratulations on being here. It is a tremendous accomplishment. I am an attorney with the California Attorney General's Office. More interestingly, I'm an alumnus of this program. I participated at the national finals way back in 1995. So I've been on that side of the proverbial table or camera.
My name is Wad Rahal, and I'll be attending Cornell University to pursue a career in architecture.
I am Sam Stockfish, and I'm joining GCU's Barnabas Pastoral Program, where I'll be studying for my bachelor's in Christian Studies and my master's of divinity.
Hi, I'm Haley Howerton, and I'm planning on pursuing a degree in cybersecurity. Our coaches are Miss Lindblom and Miss Litzenberger.
Excellent. We have chosen question 1 for you, which I'll read. A result of the decision in Wisconsin v. Yoder is that, quote, any parent guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs. Do you agree or disagree with this result of the decision? Why or why not? What words, if any, are found in the U.S. Constitution or in state constitutions that protect the right to an education? And how have courts balanced religious beliefs with other rights?
Ziploc bags taught us that yellow and blue make green. Just as we need the correct amount of each pigment to create the color green, the U.S. government must balance the religious rights of the people with the interests of the government to abide by the social contract.
So we agree with Yoder because general law should not be used to burden religious beliefs. However, it is challenging to balance education with religion, as education is not a guaranteed right. Yet we must ensure that there is a right balance of yellow and green, yellow and blue, to create the exact shade of green for the people.
Wisconsin's compulsory school attendance law, when applied to the Amish community, was held in violation of the First Amendment's free exercise clause. Under the test established in 1963, Sherbert v. Verner, the state did not prove a compelling state interest. The court explained that Amish children leaving school would not harm them or the state.
Furthermore, Chief Justice Berger explained that by exposing Amish children to worldly values, the attendance law substantially interfered with religious development. We agree with the opinion of the court because the state failed to meet the requirements of strict scrutiny, which should be applied to all free exercise cases. Additionally, education is not a constitutionally protected right, making the compulsory education law an infringement on the Amish religious freedom, thus failing to meet strict scrutiny.
Importantly, 1973 San Antonio School District v. Rodriguez held that there is no fundamental right to education. While the right to education is not in the Constitution, the spending and necessary and proper clauses of Article 1, Section 8 allow for federal education funding. Additionally, state constitutions outline funding, create guidelines, and place limitations that affect school systems.
For instance, Sections 1 and 9 of Arizona's Constitution establishes a general and uniform public school system and requires proper funding for its maintenance. As well, 22 states have declared education to be a fundamental right. Even though the Constitution doesn't guarantee education as a right, the Supreme Court and Congress have declared that if the states provide an education, it must be done equally. So 1954, Brown v. Board of Education used the 14th Amendment's Equal Protection Clause to provide equal access to education by desegregating the schools.
Additionally, the 1974 Equal Education Opportunities Act and 2015 Every Student Succeeds Act are attempts to provide equal opportunity in education for all students. Even so, education is not a nationally recognized fundamental right.
While education is not a guaranteed right, we do see that the courts have attempted to balance free exercise of religion with other rights. The court first used the belief action distinction established in 1940 Cantwell v. Connecticut, then shifted to the standard of strict scrutiny and compelling state interest established in Sherbert. Then, 1990 Employment Division v. Smith denied 2 men compensation after being fired for consuming peyote as part of a religious ritual.
The court abandoned Sherbert, shifted back to belief action distinction, and used the rational basis standard. Scalia explained, The free exercise clause protects religious beliefs, but does not insulate religiously motivated actions from laws unless the laws single out religion for disfavored treatment. In response, Congress passed the Religious Freedom Restoration Act of 1993, which restored the use of strict scrutiny. The legislature argued that the court had effectively overturned case law, including Yoder and Sherbert, which used strict scrutiny to examine restrictive religious laws.
Seeing this in application, 2014 Burwell v. Hobby Lobby held that the government must provide exemptions to the contraceptive mandate of the 2010 Affordable Care Act, which violated RFRA. So the court sided with the religious beliefs of a corporation over a woman's right to contraception, explaining that the government had substantially burdened religious freedom by not accomplishing the government interest in the least restrictive manner.
If there's too much yellow pigment or if there's too much blue pigment, the color green will not be achieved. Rather, some unfortunate outcome occurs. In the same way, there's no exact science to balancing religious expression with government protection. All the while, the US government must continue to paint with the right color of green for all the people.
Excellent. We'll begin the follow-up section now. Let me start you off with this. You talked about balancing free exercise with other rights. How are the two religious liberty clauses in the First Amendment, the free exercise clause and the establishment clause, balanced in the public school context?
I would say that an individual's free exercise of religion can come into conflict with the establishment clause over public schools, which could be for its benefit. So in 2006, we see a court case called Harper v. Poway Independent Unified School District, where we see a school actually punished a student for wearing anti-gay religious messages upon his shirt. And this student eventually accused them of violating his free expression. So the court was called in to decide the case. And they ultimately said that this was actually constitutionally acceptable, given the fact that the school was trying to protect the rights of the gay and lesbian students that were currently there. And therefore, his freedom of expression was in violation of their equal protection clause. And therefore, we see that the judicial branch has shown that when religious rights come into conflict with others, it has to maintain the general welfare for everyone.
Also, it's also important that education, especially with religion, that free exercise of religion is separate from the establishment clause, because citizens are allowed to practice whatever religions that they believe, but the government cannot establish a religion or discriminate against a certain religion. And so in 1962, Angel Vital, the court ruled that it's unconstitutional for state officials to compose an official school prayer. And this is because they don't want an establishment of an actual religion in public schools, which is this idea that while students are able to practice their religions however they want, the schools themselves cannot place an actual religion and establish it in the public schools.
Just to expand upon the establishment clause, where it most comes into conflict is with funding. In 1971, Lemon v. Kurtzman, the court held that states cannot provide funding for religiously educated institutions. In 2020, Espinoza v. Montana Department of Revenue, it held that they cannot provide state aid to parents of those who attend religious institutions through vouchers.
Should a right to education exist in the US Constitution? Should we put one in?
Actually, in 2020, Gary v. Whitman, the courts did hold that there is a basic fundamental right to what they call a basic minimum education, which is literacy. However, I think we need to go further. In New Hampshire, there is a literacy rate of 94.2, while in California, there's a literacy rate of only 76.9%. We need more resources to provide for these students. In the case 2020, Cook v. Raimondo, Detroit students fought for better education. However, the courts denied them this. Justice stated that this is not a wild-eyed attempt at expanding due process, but rather a cry for help.
However, I would immediately disagree with this idea that we should make education a fundamental right. In 2016, Gary B. Snyder are Gary V. Snyder, we see that Judge Eric Murphy in his dissent, when talking about whether education should be a fundamental right added to the Constitution, he argues that it would immerse federal courts in a host of educational disputes far outside our constitutionally assigned role to interpret text. He talks about questions such as, when do textbooks become unconstitutional? Can the courts force states to raise taxes in order to meet certain standards, and so forth? So we have this understanding that if education was made a fundamental right, we would see a imbalance in the separation of powers and even a possible threat for federalism.
I would actually have to disagree with Sam and say that public education is very important. Even our founders and the colonists found the importance of it even before the establishment of the United States. For instance, back in 1635, public schools were actually established in Boston, and this was used to prepare boys for college preparation. And so we can see that even though it was not even established inside our Constitution, we still valued education. And so other countries also value education, such as Cuba, which provides public education from elementary school all the way to universities and is regulated on a federal level, which just shows that even if education is regulated on a federal level, it still is useful to implement a proper and equal education and ensure that the citizens have a high quality education and a high literacy rate.
I wanted to shift gears a little bit to talk about an issue that's come up a bit recently. Can a state enact a pandemic-related restriction that says, in groups larger than 100, we're going to limit capacity to 25%, and then apply that restriction to churches so that their capacity were limited? Is that constitutional?
Yes, I do believe that is constitutional. We can look at 2020 South Bay Pentecostal Church v. Newsom, which was a court case in which the church said that the 25% building capacity that California was enforcing during the pandemic was unconstitutional, as it was violating their freedom of assembly and freedom of expressing their religion. Yet we see that the court actually ruled against this, given the fact that it was for the benefit of the people. So Judge Roberts actually says that the Constitution entrusts the state authorities in order to maintain the general welfare of its citizens. So when we see that we're in the midst of this state of emergency, there needs to be certain regulations that are put forth that may violate someone's freedom of expression, because we don't want COVID to continue to spread and so forth.
I agree with Sam. The government should be able to constrict or restrict gatherings if it's for the common welfare. Our preamble promises that we will protect and defend the common welfare and all people. Therefore, we should be able to put aside our individual rights to protect the common good, as South Korea does with their contract tracing.
In relations with the pandemic and wearing masks and quarantine and vaccinating, it's important to note that even during 1905, during an epidemic with the smallpox, Chief Justice Marshall referred to the government's ability to put actual restrictions on how many people are vaccinated and the mandatory vaccines regulations law. They said it's within the police powers of the states, and that these laws help promote health and peace and morals and good order of the people, and within the rights of the state governments themselves. And so in this case, the ability is for someone to say that wearing a mask or being quarantined or vaccinated is infringement on my person, like their individual's right, is also an infringement on others' right, as they're taking away that person's right to live.
So should those limitations be done based on a balancing test or rational basis or strict scrutiny?
I'd have to say that it should be on rational basis, since rational basis is usually involving rights that are non-fundamental. And so with strict scrutiny, courts usually use it to apply to fundamental rights. And so since we're looking at the COVID-19 pandemic that's probably temporary and will be going away soon as we continue to vaccinate people and making sure that people are quarantined and masked up, we will see that this is just a non-fundamental right and just issue that we're trying to solve right now, and that the courts can use this as a way to ensure that the public is safe.
I agree with Wad to some extent, but I believe we should move it up at least one rung to intermediate scrutiny to ensure that the way that they implement this is the least restrictive, especially in our state of our nation right now, where there are anti-mask protests and arguments against individual liberty and the ability for governors to enact the mandate, such as Arizona, where Doug Ducey just recently dropped the mask mandate.
How does the Constitution protect parental rights?
The Constitution creates ways for the courts to name institutions as parents. In loco parentis, seen in Morse v. Frederick, the courts held that schools stand in place of a parent in the terms of legal cases.
There's also the idea that parents themselves are able to regulate and control their children's education. And this was established in Meyer v. Nebraska and Pierce v. Society of Sisters. And it shows that the court themselves have recognized that parents have the ability to control certain aspects of their children's fundamental rights as well.
Should parents be able to stop schools from teaching certain things to their children?
I would argue that yes, to a certain extent, we should be allowing parents to control their education and what the.
Go ahead and finish that thought.
So I think that we should allow certain parents to allow students to not learn certain subjects. As stated in 1923 in Meyer v. Nebraska, Justice McReynolds says that it's the natural duty of the parent to give his children education suitable to their station in life. So if they have religious reasons for not believing in evolution or so forth, they should continue to promote that lifestyle rather than the state telling them how they should live their lives and what to believe.
Great job. We'd like to recognize the students for their hard work and participation.
Absolutely. Would one of my colleagues like to begin the feedback round?
Sure, I can do that. Good opening structure. I like the way you started with the idea of religious rights and versus the social contract. I shouldn't say versus, but putting those two pieces together. You walked through Sherbert and strict scrutiny and issues along those lines. So I thought that the structure was nice. Talked about a bit about Smith, so along those lines. We got into the Q&A, and I think it was a good conversation. I mean, I think there were some areas where maybe there was a little bit of a lack of application of what you may have talked about in the opening, but that's how it goes, right? That's how we're pushing you on these particular questions. I thought you had some good, interesting stuff to talk about in terms of the right to education. You don't always hear Cuba raised, but that's a legit example. So I thought you guys have clearly looked at a lot of information and a lot of sources and used a fair number of them in a perfectly legit way. So I really appreciate the conversation. It's a real interesting talk. So thanks a bunch.
Yeah, I would echo that. I thought the prepared remarks did a nice job, and I too really liked the last part there. You know, from Cantwell to RFRA to Hobby Lobby. You know, you kind of went the whole history, and he did it very succinctly, which I thought worked well. On the question about balancing free exercise and equal or an establishment clause in schools, I appreciated the Harper reference. I thought that was a good example, but I really appreciated the nuance of contrasting what Engel held, right? That you can't have a school prayer, you can't have an official prayer, but that doesn't mean that students lose their free exercise rights. And I thought that was a good way to distinguish between the two clauses and show how they might be applied in practice. So I thought that was good. On my question about COVID, you know, I wish that the 2020 decision in South Bay Pentecostal was the Supreme Court's last word, but as you probably know, it was not. They've had several subsequent decisions, including very recently, where they've taken the opposite view now, that basically, you know, a very narrow view of what the states may do where it impacts worship. And so I would have loved to talk more about that. I think one thing I think one of the real challenges here in any kind of balancing of religious beliefs is that there's no question that religion is a fundamental right. And so when you're trying to balance religion against other rights, including the right to protect the public health, right, it becomes very difficult to ever come up with a reason why you can restrict this one fundamental right in the name of this other right. And I think that's the kind of the nub of this question. So I would encourage you to think more about that as you go on in your careers. But congratulations and great job.
I agree with my colleagues. Great job. What stood out to me was the recitation of, like Judge Chambers said, you obviously had read a lot of sources, different types of sources, and cited a lot of different federal statutes that related to education. That really resonated with me. I agree with Judge Glickman. The Tyler Harper example was a very salient one. One that I'm familiar with. I deal with student First Amendment rights is actually where my primary locus, and that was just an exceptional example. The thing that also stood out to me was the fact that you all seamlessly worked together, and the participation I thought was incredible, and you all offered different things and sort of played off each other very effectively. It was obvious that you're a real team. And I would just encourage you to continue your study and appreciation of the Constitution. And thank you so much for all of your hard work. Thank you.
Thank you for judging.
That's it. You guys are done, right?
Yeah.
Yeah, congratulations.
Congratulations, guys. Really fantastic job.
Good luck with the rest of your day.